If you do a mistake and you didn't mean to, will you still be held accountable? Will you be punished? Hi and welcome to this video in which we will cover the tort law in the Canadian legal system. In this video, we will cover the key elements of the tort law, some examples of how it applies to the engineering work in particular, and then we will have a look on how it could appear in the NPPE exams. An owner of a dog and that dog bits a passerby. The injured individual can sue the owner of the dog, asking for compensation for the medical care. Fair, right? And that's the main purpose of tort law. Tort law was developed to deal with civil wrong. So it doesn't have to be a crime, doesn't have to be a breach of a contract, just a mistake that causes harm. The main purpose of it is to compensate the injured parties and also to deter wrongful conduct. So everyone be careful while they do their due diligence. There are three elements of the tort law. For any case, so that the court can apply the tort law, these three elements must exist. First is duty of care. The defendant owed a duty to the plaintiff. Second, breach of duty. The defendant didn't do their due diligence. Their conduct fell below standard. Third, damage caused directly as a result of the breach of duty. Duty of care. The defendant owed a duty to the plaintiff. For example, an engineer creating a design for a client. They know that they owe a duty to provide a good quality design to the client. They also know that their design, any mistake in the design could affect the contractor that will rely on their drawings. They also know that any error in the design could affect other parties, occupants of a building or passer by on a bridge. So the duty of care is the due diligence relationship between the plaintiff and the defendant. Second, breach of duty. The defendant didn't follow good standards behavior. So their conduct fell below the standard of a reasonable professional engineer. And that's a very crucial point. That's why the courts usually ask for technical advice from other engineers when a case is raised before them to confirm what could another professional engineer do in that case and to verify if the defendant did perform the due diligence or not. Examples of a breach could be a faulty design, omitting a critical survey, failing to warn of hazards. Third, damage caused. A bridge was built and the structure failed because of an error in the design. Someone got hurt. There is a direct causation now between the injury of that individual and the error in the design. Accordingly, the tort law can be applied. Okay, there are three types of torts. First one is intentional tort. Someone deliberately causes harm, assault, defamation. And by the way, that's a very important point. So in these cases, civil wrong appeared. Accordingly, tort law can be applied to provide a compensation to the injured individual. But also, there could be a crime conducted by the defendant. So the defendant in this case can be actually sued for under two cases, not only one. One in which is for the civil wrong, but the other one is also for crime under the crime law, the criminal law. Um, Second type, which is the most common one in the engineering work, negligent torts. Harm caused by a failure to exercise reasonable care, like faulty design, car accidents, anything that included a carelessness from the defendant. Third is strict liability tort, responsibility imposed regardless of intent or negligence. For example, dangerous activities. A company deals with a harmful chemical and that chemical spilled. They will need to pay compensation to the injured individual, regardless if they did their due diligence or not. Just because they got involved in a dangerous activity, they know that they could be sued. Animal attacks is an example, as we mentioned. Someone owns a dog and the dog hurted someone. Even if they did put the pet on leash, they still will have to compensate the injured individual. Okay, concurrent tortfeasors. Let's say that several individuals or several entities did a mistake. The court can find all of them guilty. Accordingly, provide each one of them a share of that responsibility to pay the compensation to the plaintiffs. And that's what we call concurrent tortfeasors. Here is a very important topic related to the tort law, and that's actually crucial to understand so that you know how you can protect yourself. There is in all of the provinces in Canada, there is a limitation period for when tort can be applied. First one is a basic limitation, and here we will talk about the limitation periods in relation to the Ontario law. Basic limitation is 2 years, and it starts from the moment the error or the mistake is discovered. Let's say an engineer created a design and no one did notice the error until several years after. Once the error was found, the plaintiff will have 2 years to file a case, to start suing the defendant. Second is ultimate limitation, 15 years, from the day the act was conducted by the defendant. So the engineer created a design and that design has an error. After 15 years, then it was discovered. Well, that's too late. We can't sue the defendant in that case. Why? Because the 15 limits is a cap for how long a tort case can be applied against a defendant after the day their act was conducted or their error was conducted. Okay, now let's see an example of how this could be asked about in NPPE exam. And that's, I believe that's a very common theme of questions that could appear, and this is just one example. A professional member designed a commercial building and the building collapsed as a result of negligent design, which resulted in injury for some occupants of that building. Based on the rules of tort law, in that case, the engineer is legally liable to which of the following? First, the client that the professional member had a contract with to make the design. Second, the construction company that built the building based on the design, and now they are the reputation is affected because of the failure in the building, so they may also ask for compensation from the engineer. Third, injured occupants. Obviously, the answer is for all the above. The engineer will need to pay compensation to each one of these individuals and entities. And that ends our video for today on the tort law. Let me know in the comments if you have any questions about this topic, and we will have more examples and we'll cover more concepts moving forward in other videos. Looking forward to seeing you, and thanks for watching. Have a good day.